Hello and welcome to the podcast. I'm Karen Weaver. Today I'm joined by Michael LeRoy, LER Alumni Professor of Labor and Employment Relations at the University of Illinois Champaign. His research program examines employment and unions for NCAA athletes, among many other important issues. Michael, welcome to the podcast.
Karen, thanks for inviting me. We have a lot to talk about today.
We sure do. So, for my listeners, I'm going to frame our conversation around the current issues surrounding college athlete employment and NIL. You've been gathering some NIL contracts, and they provide some insight into the next evolution of athlete legal issues. Walk us through that.
Sure. Well, first of all, this is part of an academic research project, but the whole point of it is to inform the public, academic administration, athletic administration about the changing landscape of commercialized college athletics.
Yes.
So I sent an information request to all public schools in 9 conferences, the mid-sized conferences and the major conferences. I've had 7 institutions reply with documents from 5 different conferences. So I have access to the Big Ten and the SEC template. And Karen, I requested the template. I knew I don't want information about an athlete's compensation agreement. That really, you can't generalize from it at all. So I imagined that there would be a template. There is a template. And so to walk you through and walk our listeners through it, it turns out that with the Big Ten and SEC are very different from the other schools and conferences. That's not a surprise. But what surprised me, Karen, is how different the SEC and Big Ten template contracts are. So to keep it brief, these are very, very lengthy, fine print kinds of documents. The Big Ten contract is longer, more jargony, more detailed. It is a licensing contract from pretty much from top to bottom. You are, as an athlete, you are licensing your NIL in exchange for a sum of money to your school and to the conference. And this part did throw me or surprise me. It has provisions for sub-licensing and more sub-licensing. I'd never thought 8 years is like what I thought.
Yeah.
Karen, it never occurred to me that a conference could sub-license and you get this sort of ad infinitum effect. So to keep it short and simple, when athletes leave a school, if an athlete's going into the portal or their eligibility is exhausted, the school, their rights to exploit the NIL of the athlete in the Big Ten ends. But the licensed use of the college NIL of that athlete for the conference and for sub-licensees, they don't say what they are. They could be a video game. They, who knows? The athlete has lost all kind of control and monetization from that. So I'll stop there and see if we have questions, or then I can go into the SEC contract. But
that's helpful. So who do you imagine the sub-licensees to be? What types of industries, or is it the conference, or what do you imagine that to be?
That's a good question. So the obvious one would be video game or so forth. But thinking beyond that, thinking about how commercialized and entrepreneurial the Big Ten has become, it could be the College Football Playoff Organization, CFP. Okay. They have, I thought at first they were part of the NCAA. They're not. They are an LLC. They're a separate entity. And so if I tried to imagine myself as a business person, which I am not, I would think, well, during the playoffs, it would make some sense to monetize those rights, especially when you want to have look backs or build up the excitement around, not that it needs more excitement, there's plenty. But so would college football playoff as an entity get that? Who knows? Possibility. There are more event-centered sorts of activities that the conference organizes. Simple as a marathon. They could do things on a regional or a school-wide basis. But then I think of their they're business partnerships, and they're very opaque about like who are they and what are they. But I have read their tax return, and for example, they have some sort of shared entity with Fox. Apart from
Yes.
Fox's, I mean, Fox has an interest in the Big Ten. I mean, an investment. And then from there, I sort of think, well, like what would Fox as an entertainment company do with those NIL rights? And the answer is I don't know, except that this space keeps filling up with more and more sort of ingenious kinds of uses, product endorsement or tie-in, new business partners. What about private equity investors?
Right.
Because even if you keep it at that sort of simple level, we know that the Big Ten is exploring a private equity deal.
Yes.
What would the rights be, on the individual level? So I'm going to get paid, let's say $300,000. I'm happy. I give up my rights. You start rounding up all these Big Ten athletic rights across women's basketball, football, volleyball, which is big in the Big Ten, so forth. And then how does that look to private equity investors? I think that looks valuable.
Interesting.
Very
interesting. So the Power Four conferences and Notre Dame are rumored to be starting an LLC to a new co, if you will, of creating a revenue protection area where possibly the revenues might be protected from Title IX and other kinds of federal law integration. Yeah. Would this kind of sub-licensing apply to that relationship as well?
Yes. I think this kind of privatization of college athletics has been inevitable. And so I think it's just a matter of time. And I don't want the moment to pass without saying that, A, it would relieve Title IX obligations, in my view. I mean, that's not been legally tested. But B, how incredibly disappointing it would be for higher education to sell out its women athletes in this fashion, because the NIL rights are 90% male and 10% female. And so I think this goes back to the inception of the NCAA, where the NCAA really never figured out if it was an academic entity or an athletic entity. It was called a different name originally. It was what the Intercollegiate Athletic Association of the United States of America. And then they said that's too wordy. NCAA, National Collegiate Athletic Association. Yeah. But you've got two words in there, Karen. You've got collegiate and athletic. And, for the past 120 years, those concepts have been butting heads, and somehow those two domains still coexist relatively peacefully. But when you talk about the new sort of era, which I think is right for you to do, it really calls into question, like, what is higher education becoming? Because we're cannibalizing not only non-revenue sports and women athletics, but we're cannibalizing academic departments and so forth.
Yeah, there's a whole lot there to unpack. But since you mentioned women athletes, I'm going to jump ahead a little bit in our questioning and talk about Title IX and NIL rev share. Most seem to agree that the NCAA settlement will not address the issues around Title IX. So let's take a dive. Where do these NIL contracts, how do they address it? Are they the same from the football player to the women's basketball player to the track athlete in terms of gender and revenue distribution? What are your thoughts?
Well, first, we started talking about the template contract. Yeah. And it's opaque on that issue. So that's important to get out there. There's nothing on the surface that indicates which way it's going to go. But that's a small point. I just wrapped up a study that's going to be published in the University of Cincinnati Law Review. And I went with them in part because they'll get it out the soonest. It'll be out May 8th or 9th. And this is very time-sensitive data. But I used the NCAA's own data. And people should know that there's a research site. It's pretty deep on you got to go through 3 or 4 filters or layers and you get there. But they're starting to log in self-reported NIL deals from athletes. And so what I did is I filtered for Division I basketball, men and women, because it offers, Karen, the best apples-to-apples comparison. You can't compare football at all. You can't compare softball to baseball and all of that. So it was the best comparison. And among the Power Conference schools, I found that men were reporting an average amount of about 171,000 in the first half of 2024, and women were reporting about 16,000. It's a 10-to-1 ratio. Karen, if we think about that number is very close to what the house settlement looks like. It's distributing about 90% to the men's sports based on a sports economist's analysis that's the measure of lost broadcast NIL.
Mm-hmm.
If fans are listening to this, they would say, well, if I think about it, about 90% of my time watching activities is men's and 10% is maybe women's. I mean, it just kind of all matches up 10-to-1. But the House settlement is not addressing it. It's up to schools to address it. And I have no confidence that it will actually take place because the money speaks so loudly on the men's side of it. It's not that I think these are people who don't care about women's athletics. I think they do care about women's athletics. But at the end of the day, they're running a business and they're sort of on a hamster wheel that keeps spinning faster and faster and faster and faster. It's just amazing. In the past year, with schools such as Ohio State, Alabama, and others reporting very large athletic budget deficits and going to their university administration and asking for outright subsidies or loans. I mean, it boggles the mind, Karen. I mean, I have great respect for Ohio State as a research institution. Their students come to our school and they're very well prepared. They're academically rigorous. Their athletic program, one thing I love about Ohio State athletics is they got some 30 plus. They have a full assortment, and that's a lot of opportunity for athletes. So hats off to Ohio State. How can you be 30 million in the hole? I mean, how does that, and I'm not picking on them. I'm just saying, if one of your top 2 or 3 institutions is losing money when the pretext is we're making money, you have to stop and say, why are we going deeper into this?
I actually did see an answer. A reporter asked the Ohio State athletic director about that, and he said they were short 1 full home game this year. This is the lowest number of home games they've had in a number of years, which in a stadium of 102,000, you could easily lose more than a few $1 million in a season. But I understand your point.
Yeah, and I don't want to dwell on them too much. They're also, but taking the spotlight off Ohio State, the way our major athletic programs are structured, half of them, they're going to be firing coaches. 2 or 3 or 4 schools in a season, at the end of a season, will be firing a coach. And it's a coach's market still. And so you can count on 2, 3, 4 schools are going to have to eat a big contract.
Yeah.
And when that happens, and it keeps happening over and over again, they're going to go out, and the next coach that any one of these schools hires, they're going to make a bigger obligation. So it's the spiraling.
No, they're like hamsters on a wheel. They just keep spinning faster and faster, and they don't generally understand how to cut back because everything is about spending what you make and maybe a little bit more.
That's such a good point. There's no incentive to save. And, back to the NewCo model, at least with some sort of privatization, you have much more financial flexibility to do this. My concern is, how much do institutions, educational, we gave birth to these entities. Don't we have any kind of shareholder interest in that, ownership interest in it? Who knows what this will look like? But experience tells us the academic side of institutions, the benefits, they're always overstated. Like, you'll get more applicants, you'll get alumni engagement, you'll get donor support. True. but overstated, overstated, overstated.
Just did a podcast on the tropes that we still use called the Flutie factor and the Cinderella teams in March Madness. These are going to drive enrollment and retention, and it never happens.
That's right. It's like an economist making an analysis based on one set of data.
Exactly.
They know they shouldn't do that.
Exactly. So let's shift into this whole idea of why you think that presidents and other university leaders are so staunchly against unionization, collective bargaining, and, God forbid, athlete employment. Why are they so against this?
Well, first of all, most employers are against unions. So, a basic answer is there are some employers who do favor unions. They're in the construction industry. They have good reasons for it, but so forth. I would like to sort of turn this on its head, Karen, a little bit and say, why now do NFL players want to disband a union and the NFL, for example, or the NBA, for example, they want to have a union. They want to.
Okay.
So there's a legal explanation, and it's paradoxical. So if you're listening closely, folks, you got to think counterintuitively, because intuitively, if you're a major institution, you don't want to negotiate with a union. But if you do have a labor agreement, you are shielded from antitrust liability. So earlier in my academic career, I didn't really study college athletics. I studied professional athletics. Oh. I looked at 22, all of the strikes and lockouts in all of the major team sports. Only a union won only one strike. It was the baseball players in 1994. They went on strike in August. Incredible leverage they had, and they prevented the sport from having a salary cap. To get forward in this analysis, when the NFL players went out on strike in 1987, their strike collapsed spectacularly. Yeah. Here's if I were speaking directly to a president, I would say, please listen. The union disbanded. They disbanded after working so hard to form itself. They then filed an antitrust lawsuit. They then won, and they spent the next 20 years under direct supervision of Judge David Doty in Minneapolis, Minnesota, where they achieved in antitrust what they couldn't achieve in collective bargaining. So how did the NFL get hoodwinked into that? Because that's what happened. All right. And the answer is the NFL didn't realize that when they have a labor agreement, okay, that they could be exempt from antitrust. So how that situation happened is the union at that time was allowed to disband. That's the key part. Now you don't have a labor relationship. Now the labor exemption doesn't apply. If the labor exemption doesn't apply, then antitrust applies, and look out. Now that's what's happened to the NCAA the past 11 or 12 years with O'Bannon and Alston and House and on and on and on. Universities don't have a labor agreement. There is no employment, and therefore there is no labor exemption. And therefore, you can be sued for this anti-competitive rule, that one, that one, that one, that one. That's what's happening. Now, speaking again to university presidents, I know that you want Congress to pass legislation for you. That is a solution for you. I get it.
It is.
Is Congress going to legislate anything in the first year of Trump's administration? I'm asking that seriously. Whatever your perspective, left, right, middle, diagonal. I mean, do we have a functioning Congress now? I honestly don't know. And if so, where do the NCAA's priorities lie in this? So the next thing I would say, and I don't want to dwell, but I would ask folks to think about negotiating with 18 to 22-year-olds over pay and insurance and so forth for football players and men's basketball players. Just start there. who has the leverage in that relationship? What you can learn from studying pro athletics, and those are older men, is that athletes know they have a short lifespan on the field.
Yeah.
And they want to play. They don't want to strike. And when push comes to shove, the quarterbacks want more than the place kickers. They're going to get more. There's so many ways that experienced management lawyers can carve up a union at the bargaining table. I really believe that if college athletics were to unionize, you would get league-friendly agreements with basically half of the population are teenagers who are just desperate to make it to the pros, and you would get fixed labor costs. You would get an antitrust exemption that it would remove all. The NCAA has spent over $300 million in legal bills in the past 8 years. You do away with that. You do away with the liability. You get predictability. When was the last time we saw an NFL owner complain about collective bargaining?
I don't know.
It happened like 40 years ago.
Yeah.
Current generation, they love it. It's doing fine for them.
So, okay. So there's certainty in fixed financial costs. So why not do it?
Yeah.
Why not do it?
I don't know the answer to that.
Yeah.
I think part of it is, they're employers. They are employers. And so I think it comes down, Karen, to a lack of leadership. I really do. I think it's sort of groupthink that goes on. I also think, I sometimes wonder, and I'm just being perfectly candid, I wonder what kind of legal advice they get. I think they get the advice they want to hear, which is how I think the way that talk starts is make sure when this ends, we don't have a union.
Yeah.
And, I wonder if the better conversation is, of course, you're the client, and if that's what you want, but there is another way to think about it. Have you thought about it this way? Why would I think about it? Well, let's set up a meeting with the NFL, and let's let the NFL tell you what they think of collective bargaining. Roger Goodell was in the trenches negotiating and working through that. And ironically, now this is going back, but 2011, when the relationship between the players and the and ownership came out of antitrust, they were in antitrust supervision for 20 years.
Huh.
The NFL was eager to go to the bargaining table, and the players did not. And so Tom Brady, as head of this group, decertified the union. Why did he do that? That looks so odd.
Yeah.
He did it because he did not want to have a labor relationship anymore with the league.
I
If
see.
you didn't have a labor relationship, when you have a labor relationship, you're exempt from antitrust. Take away the labor relationship, we're not exempt anymore. Therefore, we can go to court. We can sue under the Sherman Act. Tom Brady, can keep playing. I don't have to go on strike. And we have a track record, just like the NCAA has developed. The players have developed over the past 11 years. We win, and we don't give up anything. We give up anything. So I
see it. I appreciate that explanation, because it absolutely plays into the athlete's hands to continuously have to file a legal thing. And like you said, $300 million in the last few years, and that's just for the NCAA. And that's going to be coming in addition to the revenue share agreements and the back pay and all those kinds of things. That's right. The $1 billion plus a year in March Madness revenues has so much taken right off the top that even less is going to the schools.
Yeah, and the sad thing, Karen, is that apart from the power conferences, the rest of the industry is suffering.
Yeah,
and we should talk about it as an industry. You should stop pretending that you've got 4 entertainment businesses, the 4 conferences, and the rest are versions of sort of the modern day athletic department brought forward from the 1920s to today, to sort of what people grew up with in the 1990s or something like that. But they're very different. They're very distinct from that. And And so I just think we're hurtling more towards this sort of breakup of the NCAA.
Mhm.
And in some ways, I think it's inevitable. In some ways, I think it has promised to restore us to amateur athletics for those schools that don't follow suit. But there's a lot of pain that's coming before that happens.
So, all right, so let's talk about those schools that are not in the Power Four, are still in Division One, and yet they're right now trying to decide if they're going to opt in or opt out. And let's just assume that what you're saying continues, the chaos continues over the next years. What should they do? Should they just realize that being a Division One member isn't all it's cracked up to be, that maybe we need to find an alternative solution?
There's a lot of soul searching that schools, I'm sure, are doing.
Yeah.
I read the statement from the University of North Dakota athletic director. That's
Yes.
one institution. To his south, the university, the state of South Dakota, the attorney general has filed a lawsuit. But I just want to wrap those schools up together and talk about Houston Christian University, this very small school that filed an objection, a very emotionally laden objection in the House case. But they're all saying the same things, which are, number one, the NCAA and power conferences have shut us out of our bylaws guaranteed decision-making processes.
Mm-hmm.
Like, who wants to be part of an association where you commit to certain written out rules, contractual in nature, and then they're not honored? And B, now you pay for the other guy's damages. Who wants to be a part of that? And I think that's where the soul searching starts to set in. And then this gets very localized. But when I spent my entire career on a big campus and a Big Ten campus, but I have visited and so forth smaller campuses. And so I can think of, pick your small campus. It could be in a suburb of Philadelphia, or it could be
It could be Temple University or Drexel University. These are mid-major Division Ones that don't have, the access that the Penn States of the world have.
Absolutely. And I get where athletics brings identity and spirit and connectivity and intergenerational conversations. And, you wear a sweatshirt and there's pride, there's all of that. And so you have to gauge what it's like to be sold out by your parent organization and keep losing money. That would make you think about, staying out of the House settlement agreement. And so I think part of it is soul searching. Who are we?
Yeah.
The second layer of soul searching could be, we're going to have to cut non-revenue sports, which is another way of saying we're going to have to cut women's sports. How committed are we to the women on our campus? Okay. And I've seen lawsuits at Michigan State, for example, and I want to be careful, between one of the North Dakota schools. I think it was the University of North Dakota. But anyway, they've cut men and women sports at the same time. This happened in the past 10 years, around COVID, displacements, and maybe some other events, budget problems. But it always feels harder for women to lose the sports because they came to it more recently, and because they're always behind to begin with, and it just sort of stamps the inferiority of their status there. But then, Karen, I also think about what's life like on a campus without sports activities. And football is a major, large, small, whatever, it's a big centerpiece activity. But if you think about the other sports and what they do for you, if you think about what hockey, a non-revenue sport, is to a northern school, if you think about what softball is to a southern school, and how it brings people together, then, I think more and more schools are saying, maybe we have to rethink this relationship with the NCAA.
Interesting. So we start to think about new presidents, people who want to become presidents. I'm talking to a number right now who want to get up to speed with how all this is working. What pieces of advice would you have as they're approaching the possibility of becoming a president? How should they think about this new era we're in?
Well, the new era we're in, and they know far better than I, is the athletic model is changing rapidly and unpredictably. but your funding model for your academic side of your institution is changing rapidly. I'm on a Research One campus where I have colleagues who are despairing of the interruption or cutting of programs. There is no tomorrow for some people already. We have a soybean lab that is shut down because of the USAID program. But even if you're in another kind of an institution that is not dependent on research funding, there are going to be Pell Grants where you're heavily dependent on financing for your student aid. I guess one thing I would say to anybody who's thinking about being a president is you're going to have to make a choice. And the choice is happening sooner rather than later. The first thing that has happened to us in higher education is we've had an executive order that ends transgender athletic participation on threat of having all your funding cut off. Well, diversity is a core value of higher education. Now, my perception, both locally and more globally among higher ed, is university presidents like network presidents, like corporate presidents, they don't want to antagonize the administration. And I understand that. In fact, I value that and appreciate it. But at some point, you got to figure out who you are. Because if you give in to bullying, you're going to get bullied again and again and again. That's how this happens.
Yeah.
There's no other way to put it except this. So if they're going to take away transgender athletics from you, okay, they've done it. They're going to take away your research funding from you. Okay, they've done it. If they're going to take away Pell Grant funding from you, okay, they've done it. What's there left to fight for? Tell me. I don't know.
I don't know either, because those are all core values, as well as access and affordability in a general way to all of higher education. So, yeah, it is a moment to stop and really think and reevaluate. And that's what I'm hoping my listeners will do in this environment, because I haven't heard anybody else explain it as artfully as you have. But so many of the schools within the NCAA are disenfranchised. And so they're just going along because there's a championship at the end of the season kind of thing. Is this what you want? I mean, that's what I keep wondering,
Well, I think also what we're talking about, Karen, and I know that our time is short, but I think part of the problem, it's a complicated problem, is presidents, one of their top 3 jobs is to raise money for the institution. It probably is their number 1 job. So they're in an environment where they are the go-to people for the institution to raise money. I appreciate that. I don't have to do it. I'm not good at that, and I wouldn't be good at it. But at the end of the day, I would just say, spend more time with a research scientist. Go to her lab and ask her what's happening. Okay. Spend more time talking to an academic program that is being threatened with programming cuts, and talk to people, listen to people. And then your Senate. I've been a part of our Senate. We're a noisy group. We're cantankerous. I get it. We're not fun to deal with. And we're very unrealistic at times. But try to find a kernel of truth in what people are telling you. Yeah. And you have to buy the whole thing. But in other words, what I'm saying, Karen, is presidents get into a bubble world a bit. And let's be honest, hanging out on a Saturday in a Big Ten venue and fundraising, I understand that's emotionally taxing, but it's also, the food's great, the drinks are great, company's great. Come on down to the end zone where the rest of us are, and sort of rub elbows with us and see what we're worried about and thinking about.
Yeah. I would certainly like to see presidents interact more with the academic advisors and the athletic trainers and the medical staff, the strength staff, because those are the folks who are doing the yeoman's work underneath the belly of the athletic department. So understanding their perspective is also crucial in this.
Well, isn't that the truth? And thank you. And sort of understanding how stress is affecting your institution. Stress is affecting the world, and it's affecting our country. But stress is acutely affecting higher ed, large and small, athletic, non-athletic, it's acute.
Michael, it has been an absolute joy to talk with you. Thank you for your conscientious, and compelling viewpoints on this topic, because I had, quite frankly, never considered what the advantages might be for the athletes to not be part of a collective bargaining agreement. But it's worth thinking about,
It's an upside down world. I'd love to talk. By the way, if people want to have just a little more on that, I have an article. Just Google how a labor dispute would help the NCAA. It would get you to a 20-page, 15-page law review article. It's readable, and it would walk you through it. But Karen, and I don't get anything out of it, and I'm past the point in my career where I count. I'm saying this to share it.
Sure.
And
yeah.
Really appreciate the chance to talk to you. And I hope we get to talk again, Karen. I appreciate the work you're doing.
I do as well. Thank you.
Take care.